In United States v. Leon in 1984, police obtained a warrant based on information from a confidential informant with unproven reliability. Police ultimately executed that warrant and arrested and charged several individuals with drug crimes. Under the law of the time, however, the warrant was invalid because it lacked probable cause. So what happens when police obtain evidence of a crime, operating in good faith, and yet it later turns out that the warrant was invalid because it lacked probable cause? You may be thinking, well, bad warrant means bad arrest or bad search, which means that any evidence obtained must be suppressed under the exclusionary rule. In United States v. Leon in 1984, the Supreme Court considered this very question and said, not so fast. How can this be? Let's find out. In Leon, the Supreme Court first adopted the good faith exception to the exclusionary rule. The exception allows for evidence to be admitted against a criminal defendant based on a bad search or arrest warrant, so long as the officer was reasonable in relying on that warrant. In reaching this conclusion, the Supreme Court weighed the purpose of the exclusionary rule, which is to deter police misconduct, against a desire for all relevant evidence to be before a judge or jury when evaluating guilt or innocence. The Supreme Court reasoned that an officer who is acting in good faith based on a warrant that is facially valid would have no way of knowing that there's a problem with the warrant. The magistrate has already said that the search is justified, so at that point the officer is simply doing their job. When we're dealing with a good faith situation, the scales then tip in favor of revealing the truth over deterring police misconduct because the deterrence value is so very small. In the words of the Supreme Court, in such circumstances, the exclusionary rule simply does not pay its way. So is this the end of the Fourth Amendment? Not quite. Courts worry about new rules or exceptions that may dramatically alter the legal landscape. So anytime you're dealing with a case that seems to do just that, ask yourself, what are the limiting principles that the court is putting in place? In Leon, the Supreme Court articulated 4 instances when the good faith to the exclusionary rule would not apply. First, when the magistrate is misled by information in the search warrant affidavit. Second, when the magistrate has wholly abandoned their judicial role. Third, when the search warrant on its face lacks any indicia of probable cause. And fourth, when the search warrant on its face lacks any specificity. So anytime you're dealing with a good faith exception instance, look for one of these 4 exceptions.